Hi there, everybody. My name is Ruth-Ann Toups. I am an estate planning, probate, and elder law attorney. I'm going to be talking to you today about some estate planning, the kind of estate planning that we usually like to think about, not only when we are younger, but also when we age. So I've been practicing exclusively in the areas of elder law, estate planning, and probate since I graduated from law school and became a lawyer a little bit over 6 years ago. I love this area of law because there is so much planning that can be done to avoid some really unfortunate situations. And so today we're going to talk about some of the really interesting, I call it savvy estate planning that we can do. And we're going to talk a little bit about some threats and some scenarios that we've seen that can lead to some not so great outcomes and consequences. The good thing about, I think, estate planning and elder law and probate that's different than other areas of law is we really have a chance to make a difference. And certain things, criminal law, family law, you're kind of dealing with problems most of the time. Whereas with estate planning, a lot of times we're problem solving, which is always really fun and interesting. A little bit about me and my practice. My office is located in Spring. We're in that really interesting area where it's a little bit of Tomball, a little bit of Houston, a little bit of Spring, the Woodlands juts in here, Cypress juts in here. So we're right at 99 in Champions Forest. There's myself, and I have an associate attorney, Jamie, and some great staff that support us. We help people not only with the documents we're talking about today, but also navigate probate and guardianship through the court system. And a huge part of their practice too is Medicaid and VA planning and crisis planning. What do we do if somebody's in the nursing home right now? We're not going to talk about those things as much today. We're really going to focus on these estate planning documents. So we're going to go ahead and jump in. I'm going to share my screen with y'all here so you can see my PowerPoint. So I always like to start with the information you came for, right? So we're going to start with 6 essential estate planning documents. So everyone that comes to my office and asks what should be in an estate plan, this is where we start. Sometimes we add other things to it, but we always want to get these 6 documents in. So we're going to kind of talk about each one in turn. The first document, and the one that you've probably thought of already, is your will. So your will is about what happens to your stuff when you die. But your will is also about who's in charge of making sure that those people you've named are getting your stuff. And that's the factor that gets overlooked a lot of times. So I have a lot of clients that come in and they've got a pretty good idea of who's getting their stuff, but we haven't thought about who's going to be in charge of that. We often call that our executor. Sometimes it's called a personal representative of the estate. So we want to make sure that in our estate plan, we are planning not only for who's getting our stuff, but who's in charge. And you're going to see that theme a lot today, because I see a lot more issues actually with who's in charge than who's getting the stuff, right? It's a pretty big question. So in our will, we want to address that. We're going to talk a little bit later too about some special things we can put in the will, some special tools we can use to make sure we're planning. If we have a spouse that might need long-term care, if we have a special needs child or grandchild, if we have a minor child or a minor grandchild who might be a beneficiary, there's some things we may want to think about critically when we are drafting our will. The second essential estate planning document is your healthcare power of attorney. So this is a document that allows you to select who would make medical decisions for you if you were unable to make those medical decisions for yourself. And this is a very important document for a lot of us because we really, again, want to think about who's going to be making those decisions. This only comes into play if we can't do it for ourselves. So if you can't act on your own behalf, who do you trust to act when you can't speak for yourself? The law does have a default here. I think that's always important to point out. So when you have a will, if you don't have a will, the law has a default. We have something called the laws of intestacy. Basically, the way I explain it is Texas is going to write a will for you. Sometimes they do an okay job. Sometimes they do a really, really bad job, especially in cases of blended families. They do a pretty bad job. And it's always going to cost you more money. With your healthcare power of attorney, there's also a legal default, something called the Health and Safety Code. If you didn't have a medical power of attorney, the Health and Safety Code dictates who would make medical decisions for you if you weren't able to do that. And for some people that works okay, but there's a lot of people that doesn't work so well for. Maybe you wouldn't want your spouse to be the first decision maker. And there's a lot of reasons for that. They could be having their own health issues. They could be estranged from you, or they maybe aren't the best representative of your wishes. Maybe you don't have a spouse, but you have 3 adult children. Well, the law says that all 3 of them have to agree on medical decisions. So kind of like our will, the state could do it for us. We may or may not do a good job. It's really important to have our wishes lined out. We always make sure we put a HIPAA release inside of your healthcare power of attorney as well. We want to make sure that that power of attorney has the right to receive medical information that could be critical when it comes to making a decision for you. The third document is honestly what I would say possibly our most important document. It is your statutory durable power of attorney. It's a lot of times called a financial or a legal power of attorney. It is honestly, I think, the most important document we do sometimes because it allows someone to not only make decisions, but take actions. I call it jumping through hoops for anything that's not medical. We could think of a whole laundry list of things, whether that's dealing with your bank, whether that's dealing with your insurance or the IRS or Medicare or real property transactions. Powers of attorney have about 3 pages of powers that they're able to do or not do, whatever you want. The problem with this document is if you don't have a statutory durable power of attorney in place, the legal default is a court proceeding. The legal default is a guardianship. We're going to talk more about those later today, but this is what I think is one of the biggest threats to estates that I see, because what I'm seeing in practice is frankly more and more guardianships. As our society becomes more litigious, I'm seeing fewer and fewer banks want to say, well, I know that Jim is Bob's son, and I know that Bob would want him to be able to cash this check, so we're just going to let him do it. The world's kind of moving away from that direction. We're full of more corporations buying out smaller banks. We're full of more rules, and I don't blame the banks and financial institutions. Unfortunately, we're seeing more dementia and Alzheimer's. We're getting into these stickier situations. You know, the good news is we're living longer. The bad news is we're living longer. So this statutory durable power of attorney is helping us sidestep these guardianship issues. We're going to talk more about that in a little bit. The next one is your advance directive. It's also known as your living will. This is also a really important document to have in place if you have strong feelings about what would happen if you were on a ventilator or a respirator and 2 doctors said it was the end of your life. Your condition's terminal or irreversible. It's very, very different than a DNR. And I see the 2 of them confused a lot. So a DNR says, if I fall out of my chair right here, right now, I don't want you to do anything to resuscitate me. Let me go. I know very few people that feel that way. Usually that's more of when we have a terminal illness, when we're at the end of our life, where resuscitation would possibly cause more harm. It would extend the end of our life. We wouldn't want to do that. Well, an advance directive is much further down the road. We've fallen out of our chair. They have resuscitated us. They've taken us to a hospital. We've been there for a week or 2. They've run all the tests, and 2 doctors have said, you know what? I think there's been a brain injury. We're not coming back from it. Do you want to stay on a ventilator or respirator? Really, do you want your loved one to stay on a ventilator or respirator? That's the document that's allowing us to make those decisions. Not everybody wants a document like that, which is understandable. In the absence of a document like this, the decision is going to fall to your healthcare power of attorney. So I always counsel my clients on this document needs to be thought about hand in hand with that healthcare power of attorney. Do you trust that power of attorney to make the decision that you want to have made? Or would you like to take that burden off of them? Do you know what you'd want to have happen regardless? And you want to make sure that it's followed by that healthcare power of attorney. The next document is our appointment of agent for disposition of remains. This document allows you to say who you'd want to be in charge of your body when you pass away. This is where we're going to put things like burial and cremation requests. It's important to have this because the law again here presumes that all of your next of kin need to agree on what happens. And believe it or not, I have seen more disputes over handling someone's remains than almost anything else. I think there's a couple reasons for that. Usually someone has very recently passed away, so we're all very emotional about what's going on. And then there's some really deeply held beliefs about burial versus cremation. There's a lot of religious beliefs that factor into that decision. There's cost concerns that people are sometimes thinking about, unfortunately. We have to think about what wishes are. And I know from my own personal experience in my family, people really have changed their minds on burial and cremation over the past couple of years. And so what I'm seeing more and more is I'm seeing maybe mom said 15 years ago she wanted to be buried, but last year she said, no, I really want to be cremated. Well, 15 years ago, she may have told her son that, and last year she may have told her daughter that, and they both are advocating because they both feel like they're doing what mom wanted, but we have a real issue. And sometimes the only way to resolve that is going to court. So this appointment of agent for disposition of remains says, you know what, I only want this one person. And on all of these documents, we're putting backups, right? So if Sue couldn't do it, then Bill's her backup. And if Bill couldn't do it, then John is Bill's backup. But we want to make sure that there's just that one person that can make that decision, because unfortunately, without that one person, we potentially face some conflict that may end up going to court. The last and final document is your declaration of guardian. And this kind of goes into that guardianship discussion we're going to have here in a little bit. It is a guardian for you. So if something happened where you needed a guardianship, and we're going to talk about why that would happen a little bit later. If it did, this document says this is who you want your guardian to be. And what that does is twofold. One, it's a little bit protective. So if somebody wanted to come in and try to argue that they wanted to throw a power of attorney out, for example, if you have a declaration of guardian that has the same person named as your guardian as your power of attorney, it's not going to get them very far. So we kind of have some protection in forming a guardianship, first and foremost. And second of all, it also is a really good tool if you had to have a guardianship to make that process cheaper, easier, and faster, which ultimately would save your estate money and hopefully whoever's in your life, whether that be your children or other friends, family members, it would make their lives a little bit easier as well. So those are the 6 essential estate planning documents. Sometimes we layer other things in, especially for my families that have minor children. We're going to add a couple extra documents. Sometimes for my Medicaid clients, we're going to add a couple of extra documents. But we always want to make sure we have these 6 basic documents, whether we are 25 or whether we're 85. And this is kind of what comprises our base estate plan. There's some other things we want to think about, though. There's some more tools that we may want to call in, we may want to use. The biggest one is a trust. And you may have heard of a trust before and wondered, what is a trust all about? Well, the simplest way to think of a trust is to think of a trust like a wagon. So it's one of those old radio flyer wagons, right? So a trust essentially has 3 parties involved. A trust has a grantor. Some people call it a settlor. That's the person who creates and typically the person who funds, means puts the stuff into the trust. So if you're the grantor, you're building your wagon, right? Then we have a trustee. That's the person who can control the wagon. So imagine the trustee holding the handle and pulling the wagon, right? Then we have the beneficiaries. The beneficiaries are the people who can actually enjoy what's in the wagon. So the very legal term for a trust is the bifurcation of legal and equitable title. What are all those crazy words mean? It just means that we're splitting legal title versus equitable or enjoyable title. Who gets to enjoy the things in the trust? In my office, we often use a candy dish to show this. And I like to use the candy because we can imagine a beneficiary eating the candy. We can imagine the trustee as the person who can take the candy out of the candy dish, right? Beneficiary can't reach into the dish and the trustee can't eat the candy unless they're one and the same. So a lot of times when we create a trust, we are initially all the things. So a lot of my couples that come in and we're doing some estate planning, we'll create a trust and they will be their own initial trustees. they're also their own beneficiaries as long as they're living. It's what happens when they lose the ability to be trustee, whether through incapacity or other factors, or when they pass away. It's that makes a trust very different than other documents. Because with a trust, we sort of have a living, breathing entity. We have this thing that keeps going even if we can't keep going. Think of it kind of like an Energizer bunny. When we have a will, all our will is doing is our will is saying, when I die, this is how I want things distributed. But it's not really providing a mechanism for that. That's what the probate system's for. We're going to talk about that in a little bit. A trust is not only what you want to have happen, but it's actually the vehicle, the mechanism for how we're going to pass those things. So what does that mean? What does all that mean about trust? It means that trust can do some special things, namely avoid probate. So we're going to talk about probate in a little bit. One of the best ways, one of the best tools we have for avoiding probate is a trust. Why is that? Well, you'll see here with a trust, you put your things into the trust. By putting them into the trust, when you pass away, they're owned by the trust and they're not owned by you individually. That means we don't have to go through the legal process of passing them from your name to someone else's name. So there's lots of different types of trust. I often get questions when we're talking about trust about, well, can this trust do that? Can this trust do this? Especially when it comes to taxes. For most of us, the kinds of trusts we're going to use are not going to have any effect on our tax liability. Our taxes will be exactly the same as they were before we did the trust. For some people, some what we call higher net worth people, we're going to talk about what that means in a little bit. Trust can be powerful tax planning tools, but for most of us, when we're talking about trust, we're concerned more about things like probate avoidance, like planning for special needs beneficiaries, like blended families, out-of-state property. Those are the kinds of things that usually drive us more to a trust plan. Very few of my clients have an estate where we really need to be talking about taxable estate planning, but we'll talk about that in a little bit. So when we're thinking about all the different types of trust, there's really two important distinctions that we want to make. The first is between testamentary trust and living trust. So every will that I do typically has at least one, if not more, testamentary trust in it. Testamentary trust just means it's a trust inside of your will. So it can be very, very short. A lot of my testamentary trusts are. They're just a couple of paragraphs, maybe half a page. And basically the way to think about these trusts most of the time is that they're contingent. They're little springs, like springs in a pin. And if you need them, they'll spring to life. And if you don't need them, when you pass away, they'll just never come into existence. Well, why would we want testamentary trusts? We usually use them as a safety net, as a precautionary measure. So we use them a lot of times when we have minor beneficiaries. Our goal is that we live longer than the time that it takes for the minor to reach age 18 or 20 or 25, whatever age we're choosing in that trust. But if we pass away and we leave that younger person, we don't really want them to be able to control those assets. Or if they're not yet 18, they're not legally allowed to, and we don't want a court involved. So we use a testamentary trust for minors so that until they reach a certain age, we've got this trust that springs to life and takes over and kind of manages their assets. And we get to choose the trustee in those situations. So we know who's going to be managing the assets for that beneficiary. The other major distinction about trusts is we have living trusts. So living trusts are more like the red wagon because we're setting them up now during our lifetime. So if you come to me and you want a trust-based plan, we're going to be talking about creating a living trust. If you come to me and you have a minor child or maybe a beneficiary who might be on public benefits, and we're talking about a special needs trust if that beneficiary outlives you, those are the kinds of trusts that we'd probably use testamentary. We'd probably just add them into your will. Whereas if we're concerned about, again, out-of-state property, probate avoidance, blended families, we're usually talking more about going ahead and creating a living trust now. With both testamentary and living trusts, there are revocable and irrevocable. Typically, testamentary trusts are going to be irrevocable. They're set up by someone, they're created when someone dies. We don't want future people to be able to revoke or to change that trust. With living trust, though, we have a split. A lot of living trusts are revocable. A lot of them are irrevocable. There's some really complicated legal reasons why we might choose revocable versus irrevocable. There's certain public benefits reasons, certain tax reasons where sometimes trusts have to be one or the other. Usually they have to be irrevocable versus revocable. A revocable trust just means that we can take the trust back in its entirety. We can change it in its entirety. Whereas irrevocable means it's much more difficult. It's not impossible. You can actually sometimes change or completely get rid of, terminate an irrevocable trust. But there's a lot more hoops to jump through, and it's not always possible. Whereas a revocable trust, we can always change it. So usually, again, when I have spouses coming in and we're doing some of that revocable trust planning, that living planning, we're using revocable trusts at least as long as both spouses are living. When that first spouse passes away, we may want the trust to be unchangeable. We may not want the surviving spouse to be able to change, or we may want them to. Sometimes we leave them fully revocable, but usually when both spouses pass away, we want the trust to become irrevocable, unchangeable. We don't want the beneficiaries later on to be able to change who the future beneficiaries are, right? So that's just kind of a little bit about some of the words or language you might hear around trust. So we've talked about some of these already, but there's some really specific reasons we may want to consider a trust plan. This is one of the most common questions I get in my estate planning consults. People come in and say, well, what's the deal with a trust? Do I need a trust? Probably not. Some of us need trust. Not all of us need trust. Every attorney is different. Some attorneys love trust. Some attorneys hate trust. I'm probably a middle ground. I like them. I use them often in my practice, but I don't by any means think everybody needs a trust. This is the first time, but probably not the last time today, I'm going to tell you, you cannot trust Google. I have people that come in all the time and say, well, I Google searched and I know that I need a trust. Well, here's the thing. The law is different from state to state. We do not have a national law when it comes to estate planning. We have some model codes, so rules look very similar from state to state. Some states have the same rules, but no two states have the exact same rules for everything. Maybe pieces of the rules are the same. So if you go to Florida, for example, most estate planning attorneys in Florida are going to tell you, you must have a trust. Probate there is such a difficult experience. It is such an expensive experience that it is almost borderline malpractice is how it's been described to me. If you are an estate planning attorney in Florida and you don't do trusts for your clients as a routine matter. That's not the case in Texas. So if you're Googling and you see somebody saying you have to have a trust, that's not true. In fact, I've seen trusts go really wrong. I've seen trusts end up costing people more money than if they had just done a will plan instead. So the most important thing about trusts is not everybody needs them. And it really is different from situation to situation. You need to go and talk to somebody and let them know, be honest. When you are seeing an estate planning attorney, you want to put all the cards on the table. I ask my clients to fill out a form before they come in and see me. And I know it's difficult. People often don't always want to reveal everything, but in order to come up with the best solution for you, I've got to have all the information. So what are some of the specific things that we may want to factor in with a trust? The first is incapacity. So trusts do a little bit better of a job of planning for potential future incapacity. So sometimes I have clients that have a diagnosis where they know that they will probably lose capacity in the future. In those cases, a lot of times we talk seriously about a trust plan. We can use a power of attorney, but for certain things, for certain assets, certain estates, certain situations, trust can actually be better. Namely, when we have a lot of things in discrete places. If we have a lot of different investment accounts, especially if we have a lot of different pieces of property, sometimes it's easier to have them all in the same wagon and kind of have one person managing that wagon versus having a power of attorney kind of spread out everywhere. One of the biggest and most common reasons in my practice for using trust is remarriage of a surviving spouse and blended families. So when I have families come in and the spouses have a child from outside the marriage, especially if they have children from outside the marriage and children from inside the marriage, a trust is almost the only solution that I will recommend in those cases. The difference with a trust versus using a will is with a trust, we can essentially freeze some of the assets, the deceased spouse's separate property and up to half of their community property when they pass away. So the surviving spouse maybe can still access it and we can monitor all those terms and when we draft the trust, but they couldn't change where the money's going to. So it's one of the best ways that we can protect those children from outside the marriage to make sure that they will eventually inherit something. The next one is property in other states or even other counties. And this is another big one in my office. If you have property outside of the state of Texas, it's very likely we would have to do what we call an ancillary probate. We would have to probate in Texas and then go and probate in that state. Probating in multiple states is very expensive. You have to find different lawyers in every state that are licensed there. It can be very time consuming. So if we have property in other states, we want to think very, very seriously about doing the trust. And some of my clients that just have property in several different counties in Texas, there's enough of a benefit to make it make sense. We want to sometimes protect our beneficiaries from divorce, from creditors. One that I'm seeing more and more lately is I've got families coming in that have adult children that still have substantial student loan debt. We can do some things with trust to try to protect those future beneficiaries. Special needs beneficiaries are one of the biggest drivers. I do a lot of special needs planning in my office, a lot of special needs trust. With special needs trust, there's two major distinctions. There's what we call first party special needs trust, and there's third party special needs trust. First party special needs trusts are funded with money from the person who is getting the benefits. They have to have a government payback provision. Third party are what are frankly much more common in my estate planning practice. That's where someone else, a parent, a grandparent, sets up this trust. A lot of times we do them as testamentary trust, so that when that parent or grandparent passes away, the special needs beneficiary gets money from their estate, but the money that they get is not an available resource for their public benefits. So that person can stay on their benefits, whether it's SSI or Medicaid, any means tested public benefit they can stay on. And those trusts don't have a government payback provision. So you essentially get to say that for that beneficiary's lifetime, they can use that money. It's not going to disqualify them from public benefits. And then when that person passes away, you can ultimately control what then happens with that money. They're really, really great tools. They're good for not just children, grandchildren, other beneficiaries, but they're great for spouses. We use them in almost all of my Medicaid planning cases. Once we qualify a spouse for Medicaid, we want to make sure that we're planning in case that healthy spouse at home passes away first, which does happen. More than we would think it would. If that does happen, we want to make sure we have a special needs trust in their will so that we can keep that spouse on Medicaid benefits and we're not going to lose all of that money from the estate. So we do lots of special needs trusts. Beneficiaries with substance abuse issues. So unfortunately, this is what I'm seeing more and more in my office as well. There's some special things we can put in. We can build specific trust. If you've got a beneficiary that has a past history or current issue with substance abuse, we can build in some mandatory drug and alcohol testing, attending meetings, things like that, to make sure that they're not getting money that they're using to harm themselves. And then finally, we can use trust for some asset protection. In order to use them effectively for asset protection, things like if you're sued, the money not being on the table, or if you need a nursing home for them to not be accountable for Medicaid, All of those take forethought. You cannot, for instance, be sued and then move all your money into a trust and be okay. You had to have had your money in the trust beforehand. Same thing with Medicaid. It takes 5 years for transfers into very specific types of trusts to be non-countable for Medicaid. And that's something I get a lot in my practice. People come in and say, well, my husband needs Medicaid, so I need one of those Medicaid trusts and then we can get qualified. That is not at all how that works. So those are really, really good in cases where we have what I call legacy assets. If you inherited, for instance, a piece of property from your parents or your grandparents, and you want that piece of property to stay in your family for the rest of your lifetime, it's really good to do some pre-planning. We want to put that in one of these asset protected trusts far ahead of time, so that if you did ever need a nursing home, if you were ever sued, that would not be on the table. But again, it's something we have to have a lot of forethought to do. Another thing about those trusts is the way that they work essentially is really limiting control and access to the assets inside of them. So we have to be prepared that whatever we're putting in there, we don't really necessarily need. So that's why, again, I think the family farm, family property is the most relevant application to them. You don't want to take your life savings and put it in one of those trusts because you might need your life savings, right? I always like to talk about what doesn't work with trust, because a lot of times when I do these presentations, people run up to me afterwards and say, well, I need a trust. Obviously, it's a magic solution. Trusts are not always the best solution for everybody. First and foremost, trusts have to be funded to work. What does that mean? That means your stuff has to be in your wagon. If your stuff's not in your wagon, it's not controlled by your wagon. Okay. So in order to fund a trust, you actually have to transfer all of your assets after we've created the trust. And we help you with the real property, but there's a lot of things that we can't help you with. Your bank accounts, your investment portfolios, things like that. We can help talk to your financial advisor, but there's a lot of legwork on your part to not only initially fund the trust, but then keep the trust funded as you buy new assets, as you sell things, keeping the trust, what I call maintained. There's no annual fee. You don't register your trust anywhere. You don't have to keep paying me every year or anything like that. But you do need to think about that trust on a regular and routine basis. And unfortunately, what I see a lot is I see people who have been maybe sold these fancy trusts. They usually come in these big gold binders or, kind of gold leaf binders, and they're really proud of their trusts. They're really excited about them and they look really, really nice. But I start asking people, well, what's in your trust? And they kind of give me a look like, well, what do you mean? Everything I own's in my trust. I said, great. Well, where are your deeds? Where's your transfer paperwork? Show me your checkbook. Does the name of your trust appear in your checkbook? And we start to figure out that really nothing is in this trust. If nothing's in your wagon, if nothing's in your trust, it's pretty meaningless. It can only control the things that are in there, the things that are owned by the trust. We have to properly fund the trust. One thing that we do in my office is we always put a safety net in. We always do something called a pour over will. So kind of think of it like a big safety net underneath that wagon. Anything that's not in the trust, it will take and pour it into the trust when you pass away. The problem is in order for that pour over will to work, it's got to be probated. Most of the people that come into my office and want a trust, they're attracted to the idea of avoiding probate, avoiding the cost and time delay of probate. So the first thing is trusts have to be funded. Being funded takes some work on your part. Trusts are a lot more effort, not just for me, but also for you, whereas wills are a lot more straightforward. That kind of rolls into the second point. Trusts are more complicated. We have to have a lot more detail in trusts. We have to think about a lot more details and aspects. And unfortunately, that makes them more expensive to set up as well. So when you do a trust plan, you're going to be seeing these several more times. You're going to be spending more money to get the plan established. And you're going to need to be thinking about it on a regular basis after you're done. With a will plan, usually you'll see me 2 times. One of those times might even be virtual, might even talk on the phone. We'll get your information, get what we need, talk about how you want your will designed, answer your questions. You'll come in, we'll sign it, we'll explain everything before you sign it, obviously. And then we're done. You can go put it somewhere safe and not think about it again. Trusts take some time. You know, we're in it for a couple months. We're seeing each other several times. You've got homework after our meetings. And that's just not what everybody's interested in. I will say, you know, I always like to do kind of a cost comparison with my clients. For some clients, for a lot of clients, trust can be cheaper in the long run, presuming that we successfully fund it, you avoid probate. Typically, the cost of establishing a trust is much less expensive than probating and paying to do a will 2 times over, especially if you're married. Because if you're married, you have to probate when each spouse passes away. So trust can be actually cost savings in the long run, but in order for them to be cost savings in the long run, there's a bigger investment on the front end. And then lastly, and I think the most important is, trusts require a willing and competent trustee. So I've had a lot of people come into my office and we have had lengthy discussions, and they have told me all about this really great trust with all of these provisions, and all of these terms, and all these hoops their beneficiaries are going to have to jump through. And then I ask, well, who's going to be this trustee? Who's going to enforce all of this? And we're having a really hard time answering that question. Who's going to be the trustee? Well, it's pretty hard to decide. Who's going to want to be the trustee? Remember, just because we name somebody doesn't mean they have to follow through with this. So then a lot of times we talk about corporate trustees. There are plenty of people out there that you can hire to be a trustee. They come with a cost, with a fee. A lot of times I find for the right size trust, they're well worth that cost or fee. But it's something we have to think about. You know, are we designing a trust that's so complicated no one will want to serve as trustee of that trust? So those are some things that might hold us back from using a trust. Even though they're great tools, like I said, they're not the magic perfect solution. If anybody tells you there's only one way to do things, with a lot of things in life, but especially with estate planning, think critically about that, because, you know, trusts are good tools, wills are good tools. There's lots of different things we can do, and it really just depends on you, your family, your situation. So I want to kind of end today by talking about some threats to your estate plan. These are a lot of times questions that I get commonly, but they're also issues and things that I see in my practice that I'd love to see less of. So the first one is overly burdensome tax liability. We are going to talk a little bit about taxes. The next one is that guardianship. I really want to talk to you about avoiding guardianships. An unnecessary or complicated probate proceeding. We'll talk about that. And then I'm just going to touch a little bit on your spouse or you needing long-term care. I know there's another speaker talking more on that today, but those are kind of the 4 biggest threats I see to your estate and things we want to be planning for. So the first one's a hot topic, getting hotter by the day. Let's get our taxes out of the way. So people come to me all the time and say, I don't want my beneficiaries to pay taxes when I die. Those darn death taxes. I do not want them to pay those death taxes. So here's what's important to understand. Texas does not have a state estate tax. That means that the only estate tax that we have to be concerned about is the federal estate tax, which for this year is $11.7 million per person. Married couples can actually double that number with proper planning. Well, so if your estate is not worth more than $11.7 million, does that mean we just don't care about estate taxes at all? No, because we don't know what our estate's going to be when we pass away. We also don't know what the estate tax limit is going to be when we pass away. So there's some pretty big proposed changes. Just in the last couple of weeks, really, we're starting to get an idea of what may happen in terms of the estate tax limit. So prior to the last administration, the estate tax limit was lower. In fact, some would say significantly lower. It was $5.85 million. The reality was, though, still for the majority of my clients, even at $5.85 million, we just were not that concerned about federal estate taxes. So usually what I tell people is we kind of have to think about where we are, think about where we are now, think about how our estate could potentially grow, and then of course be flexible for changes in the future. So not a lot of my clients are real concerned about taxable estate planning, but a few of us are. And for those of us that are right now, we are typically using very flexible plans. A lot of those clients are using trusts. We're using revocable living trusts, where we have a lot of power to amend and to change them if the tax laws change. If your estate's worth more than $11.7 million, or if you're, I would say, within $2 or $3 million of that number, if you're over the $6 million mark, you need to be really thinking about some high net worth planning. And that's a whole separate discussion. Depends even more on your specific family, on your assets, a whole lot of different factors. But for most people that I know, most of my clients, we are not real concerned about quote unquote death taxes or estate taxes. That doesn't mean that we don't need to think about taxes, right? So one thing to think about is the gift tax. A lot of people say, well, I just want to give it all to my kids during my lifetime. Well, we would need to talk about the gift tax if you were doing that, if you're giving them more than $15,000. Not so much for gift tax reasons, for IRS reasons, for, again, the majority of my clients. But for the majority of my clients, we're worried about potential Medicaid disqualification in the future. But the tax issue that you really need to be thinking about, that a lot of people don't even know about, honestly, is the Secure Act. So the Secure Act came into existence January 1st of 2020, of last year. And the Secure Act made some pretty big changes. One, it upped our RMD age, or required minimum distribution age, from 70.5 to 72. But it also changed what happens when anyone other than what we call an eligible designated beneficiary is the beneficiary of our IRA. An eligible designated beneficiary is a pretty limited group of people. It is your spouse, your surviving spouse. Special needs beneficiary and special needs trust can be drafted properly to qualify for that. It is a person not more than 10 years younger than us, so someone within 10 years of our age. It is a person who is our child and under the age of 18. Anybody other than that, specifically our adult children, are subject to the 10-year limit on stretching. What does that mean? Before the Secure Act, when someone inherited an IRA, they could choose to stretch, use a lifetime stretch, so that when they took their RMDs, the required minimum distributions, they were able to do it over their lifetime. Means that they're taking a lot less out every year. Now they have to do it within 10 years. That makes a big difference. In the area where my office is, and I think over a lot of Houston, we have a lot of oil and gas industry folks. And what I see a lot in their industry and in many others is they're really heavily weighted in their retirement accounts, in their IRAs or 401ks from their company. And they have really nice, large retirement accounts, often in excess of $1 million. Well, if you pass away and your adult child, say you only have one child, inherits $1 million IRA from you, they will have to take out $100,000 a year for 10 years from the IRA until it is completely gone. Well, what does that mean? That means for them, that $100,000 is treated as income. That goes on their income tax return, and it can increase their tax bracket. It probably will if it's $100,000. They may go from a 20% tax bracket to a 30% tax bracket. So we really want to think about who are our beneficiaries on our IRAs. We want to think about what tax bracket are they in? What tax bracket am I in? Are there some opportunities here? Do we want to do charitable giving? There's a lot of different things we want to think about. Do I want to pull out some more money now? What I see a lot is I see adult kids who are high earners, who are in a higher tax bracket than their parents are right now, set up to inherit these very large accounts that are going to give them a pretty hefty tax consequence. And we may want to start thinking about divesting ourselves of those a little bit earlier on. So that's more of a financial planning issue than a per se estate planning issue. But I think the Secure Act has really changed the game for those retirement accounts. Anytime anybody comes into my office asking me about taxes, they're thinking about the estate tax. And I say, we don't even need to worry about that. We need to be worried about the Secure Act. You need to understand how that works and how that's going to impact your retirement accounts. So that's a little bit on taxes. That's how taxes could be a problem. Again, for most of us, it's the Secure Act, not the federal estate taxes. So guardianships. Well, what the heck is a guardianship? A guardianship is a court proceeding. What happens with a guardianship is typically someone is no longer able to manage their affairs. They are totally and completely incapacitated. They have to be incapacitated for someone to get a guardianship. What I see a lot in my practice is someone has refused to sign a power of attorney for many years. They've now lost capacity. They have Alzheimer's or dementia, and their child is trying to move them into a memory care. They're trying to take care of them. Their houses are often in a very bad state. APS might be involved. It's not a good situation. And what we have to do, the only solution to be able to legally move them, to take care of them, and to access their money in order to pay for their care is to go get a court-ordered guardianship. And they've been in the news a lot. You may have seen some of the Britney Spears stuff, the conservatorship, which is the same thing as a guardianship of the estate here in Texas, just different terminology. There's been lots of movies, lots of documentaries lately. They have a really great implication and a really great use, but they are expensive. They are time consuming. The court is involved. The information is public. It's very intrusive. And they are difficult to obtain. It's a whole process. And because of some of the really kind of unfortunate and nasty abuses that have happened in the guardianship system, we're seeing more and more reforms, which is a good thing, but it makes the guardianship process more and more hoops to jump through. So guardianships happen when we don't have a power of attorney. They also happen when we unintentionally revoke our power of attorney. I'm seeing this again more and more. Clients with dementia call their financial advisor and say, I don't want them to get anything. I don't want them to be my power of attorney. I don't trust them when they're stealing money from me. Well, they have to treat that as a revocation, even if that person's not in their right mind. They're not the arbitrators of whether they are or not in their right mind. We've got to send the case to court. So we want to make sure, again, that we're making the strongest, best power of attorney possible. We want to make sure our power of attorney has all the powers in it that they might need. We don't want the power of attorney to need to transfer money to a bank account, and the power of attorney doesn't allow them to do that, and we have to go seek a partial guardianship to be able to do that. So powers of attorney are critical to avoiding guardianship. We want to make sure that we have the health care and the durable. We do not want to have a DIY or an internet power of attorney as we age, because it really puts us at risk for potential guardianship. We also want to make sure we have checks and balances. We want to make sure we have backups on that power of attorney. I've done 2 guardianships now in the last year where there was a power of attorney and there was no backup. They did a power of attorney. They named one person on there. That person died. The only option we have now is to go seek a guardianship. So you want not only a power of attorney, you want a good, thorough, in-depth power of attorney to try to avoid that guardianship, because what we don't want is we don't want the public and the courts involved in our business. We don't want our family to have to go through that. So the last thing we're going to kind of touch on is probate. We've mentioned it a lot today. What is probate? What does it do? So probate is the legal proceeding that we go through. It's a court proceeding when somebody dies. I get asked all the time, when do you probate? What makes you have to probate? Your assets, your probatable assets. So if you die, whether you have a will, whether you have a trust, whether you don't have a will or a trust, you have nothing at all in place, the driver of the need for probate is if there is something out there that we can't transfer title to without this court process. 95% of people I know, their biggest probate asset is going to be their house. So if you've heard the term clouded title before, that's what happens. So for instance, my husband and I own a home together. If I were to die, because we're a community property state, instead of half of the home being mine, half of the home would belong to my estate, to the estate of me. There'd be a big question mark on it. Well, the problem becomes, how do we know who I'd want that half of my house to go to? Well, one title company could assume one thing, another title company could assume another thing, a third title company could be given a copy of a will, a fourth title company could be given a copy of a different will. So a probate court's job is really to be the centralized decider of facts when it comes to a person's estate. So if we have a will, we take that will to probate and we get it admitted into probate through some steps. And then that will becomes effective to say, okay, she wanted her half of the house to go to her husband. If we have a trust, my half of the house should have been titled in the trust and we wouldn't have to go through the probate process. If we had a trust and we had not deeded or retitled the house into the trust name, we'd still have to go through the probate process. Hopefully we'd have a pour over will to get into the trust eventually. If we didn't have a will, if we didn't have a trust, we'd still go to probate. But instead of having this will that's dictating how the probate process goes, we have to let the laws of Texas, the laws of intestacy dictate that process. And let me tell you, that's much more difficult. It's much more expensive. It involves multiple attorneys and not just one. So when we have probates again or assets in different states, again, we're probating in different states as well. So the driver of probate is what do we have that needs to be probated? It's really important to know too that not everything we have is a probate asset. Anything that has a beneficiary properly named on it, anything that has a joint owner properly named on it is typically going to pass outside of probate, be a non-probate asset. So again, for most of us, our house is going to be the driver of probate. If you don't own a home, if you live in a senior living facility and you have 3 bank accounts and you have your daughter named as the beneficiary on all 3 bank accounts, they would simply pass to her when you pass away, and there would be no need for probate. So pros and cons of probate. Again, when it comes to that will versus trust, a lot of people come in just deathly afraid. We've got to avoid probate. We've got to avoid probate. That's not always true. So probate has some good things about it. The best thing is a probate gives you an executor or an administrator, that personal representative, the person who is legally appointed to represent your estate. And this is really helpful. If you had lingering issues, if you had, let's say, an insurance policy, that hurricane, if we have storms and you've got an insurance policy in your name, in order to deal with the insurance company, usually we need an executor. It helps address debts. It can clear titles. It is much less simple and much less expensive than in other states. It's not a percentage of the estate or anything like that, like it is in some other states. And actually, it has not been impacted as much as one would think by the pandemic. It has been some. The issues with probate have to do more with just the logistics of getting paperwork and things like that. And we've been doing it for a year and a half now, so we've got it pretty well figured out. When it comes to hearings, though, we actually are finding we're able to get to hearings much faster. Prior to Zoom hearings, it would take me well over half my day to attend a court hearing. I'd have to drive into court, find parking, pay for parking, meet the clients, go up to the courthouse, do the court hearing, go order some paperwork, drive back from downtown. At a minimum, that was a 3-hour experience. Sometimes it launched into more like a 5 or 6 hour experience. Court now can take as little as 10 minutes. At most, it's usually no more than an hour. Walk into my office, turn on my computer, and we're able to be in court instantly. And the probate courts seem to be really happy with that. And we're hoping even as things improve with the pandemic, we may still be able to keep doing Zoom. Clients, attorneys, courts, everybody likes it. But we have to remember that we are in a court system. We don't have total control over what's happening. And so there are times where things like hurricanes and other events slow down the process. And it can be slow to begin with. 2 months is a pretty fast time to get through a probate. Usually I tell people 2 to 6 months is what to expect. It's expensive. Somebody's got to pay for the probate. There's court costs, there's attorney's costs. It is all public record. It is court driven. So the judge makes the rules. There's a lot of courts that only hear cases on Tuesdays at 10:30. So we have to find the next Tuesday at 10:30 they're available. And there's potential for contest, potential for extra costs and fees just from the legal aspect of it. So we don't always want to go through probate, but it's not necessarily something that we need to be so incredibly scared of. So we've talked about most of these, but the ways that we avoid probate are using good beneficiary designations, setting up good trusts, and using deeds. So there's some tools out there, transfer on death deed, the ladybird deed. We use a ladybird deed more in our office. The legal term is an enhanced life estate deed, and it's basically a way to put a beneficiary on your house. We really like these. We like them in our Medicaid cases because they help with Medicaid estate recovery. I use them in my normal estate planning cases too. The trick with ladybird deeds is you have to do a deed for each piece of property you own, and they don't transfer from property to property. So they work really well when my clients are in what they know is going to be the last house that they own. They will either stay in that house for the rest of their lives, or if they sell that house, they're going to go to something like a senior living community. They don't work really well if we have lots of different pieces of property, if our wishes might change over time, or if we might sell our property and buy a new property. And for each one of those scenarios, we would have to sell, or we would have to redo, we have to change the ladybird deed, and there's a new cost with each one of those. If we were going to do that, we'd be much better off looking at a trust-based plan than using the ladybird deeds. So they're a really good tool, but I think they're a little overblown. The other thing with the ladybird deed is we don't get an executor with the ladybird deed. So if we leave a piece of property using a ladybird deed to 3 children, if those kids don't get along, that's a problem. They own that house equally and undivided. So agreeing on a realtor, agreeing on a sales price, all of those things can present issues for us. The last thing that I'm not going to spend hardly any time on, but I want you to be aware of, please go see the other presenter's presentation on the most likely threat to your estate plan is going to be long-term care. A lot of people don't know, but 3 out of 4 of us are going to need help with one or more of what we call activities of daily living. I've got them up here on the screen. For a lot of people, that means that their spouse or their kids are going to kind of bridge that gap and they'll never need long-term care. But for more and more of my clients I'm seeing, they end up needing long-term care. What does that mean? It means we've got to figure out how to pay for it. Medicare does not pay for long-term care. After 100 days in a skilled nursing facility, they're not going to pay another penny. What do we do? If we have long-term care insurance, that's a great option. Most people don't have a policy. A lot of times it's too late to buy one or too expensive by the time we realize we need it. So we have to talk about what other options are out there. How do we plan for those other options? And again, that's a big part of our practice, big part of what we talk about in estate planning. And I really encourage everybody to go to that other presentation, understand more about it. You would be shocked at how the rules work. Every single week in my office, I talk to somebody who's qualified for Medicaid that had no idea that they were. So thank you so much for attending today. Feel free to check out our website. You can always call or email if you have questions. It was my pleasure to talk to all of y'all. And again, thank you so much for having me.